in the audience, who are joining us in the audience today, the format is just a little bit different. This this session is open completely as a Zoom meeting. This is not a traditional session where the speakers are on the screen. You all have the ability to turn your cameras on and to join in the meeting. And the format really is going to be much more of a meeting and a conversation today. So we encourage you to to join us in the meeting and ask questions as we go along. It is a bit of a different IPBA experience, and we're hoping that you enjoy it as much as we are so far. But what we're going to do today really is talk about trade remedies, and this is a very important tool for international business, how to deal with international competition and international challenges in the trade area. We have experts today from a variety of jurisdictions, and I'll do a very brief introduction and then turn it over to the speakers, and we're going to go through each of the topics or each of the panelists. And as I say, you're welcome to join in with questions. You can just raise your hand or unmute your microphone and ask a question as the speakers go along. There will also be Q&A at the very end. So if you want to hold your questions for a conversation until the end, that will be fine as well. Our first speaker today, well, our panelists, let me just very generally introduce everyone. Gossan Fonkem from the Page Fura firm in Chicago will be our first speaker. Augusto Vecchio from Buenos Aires from the Becker Varela firm is our second speaker. Sita Sampath from India, from New Delhi, the Servata firm, will be next. Raj Bala, Professor Raj, I should say, from the University of Kansas. And the Rice Distinguished, I should remember all of the titles. The Raj will be joining us, and then Nikolai Kupowatsky from Luxembourg. And so without further delay, Gossan, it's yours, and we'll keep the program moving. Thank you.
Thank you very much, Jeff, for the wonderful introduction, and thank you very much again for tuning into this presentation. I hope yourself and your family are continuing to stay safe as we begin to recover from the pandemic. The focus of my presentation today would be on the US government's recent use of withhold release orders, WROs, to ban the imports of products it deems to have been produced with forced labor from entering the United States, and to provide one or two recommendations on what the importing community can do to mitigate the risk of non-compliance. And I begin the presentation with really by framing the issue for context. Now, when we study trade history, the one constant we would often find is that trade policy and foreign policy have oftentimes intertwined, with foreign policy tailored to promote trade interests. Now, from a US perspective, which is of interest to me here in Chicago, for example, for the last 80 years, trade policy has been the bedrock of US foreign policy, essentially dating back since post-World War II. And I think it's within this framework that we should view the US government's recent imposition of sanctions for transactions that it deems to have been produced with forced labor or are being used to violate human rights, as has been the case with the issuance of WROs. So how did WROs become such a powerful tool for promoting US trade interests? The authority to impose sanctions on products produced with forced labor has really been in the books since the Tariff Act of 1930s. And that law essentially required the US Customs and Border Protection to stop all goods made wholly or in part from entering the commerce of the United States. And initially, this law was designed to protect US business interests from unfair competition of cheap forced labor. But in 2015, the law was amended to remove what they call the consumptive demand clause. And what that consumptive demand clause really does is it says is that you can import goods used with forced labor from into the United States so long as there is not enough supply in the US to meet the consumptive demand of US consumers. So this was really a loophole against that blanket ban of forced labor. So the removal of that consumptive demand clause essentially strengthened CBP's ability to target shipments that it suspects are produced with labor-related human rights abuses. I should also add that as we speak, two competing legislation are currently working their way through US Congress. And this legislation is titled the Uyghur Forced Labor Prevention Act. And if it is passed and becomes the law, it's going to do two things. One is going to penalize Chinese officials for the alleged abuse of Uyghurs within the Xinjiang region. And two, it would effectively ban all products made with, all products originating from the Xinjiang region of China from entering the United States unless the importer can prove that the goods were not produced with forced labor. Now, in the last 5 years or so, for example, through the issuance of WROs, CBP has taken actions on tobacco from Malawi, seafood caught on numerous Taiwanese vessels, disposable gloves from Malaysia, which last week that ban was actually lifted, and on numerous organizations operating out of the Xinjiang region of China. Now, we've been talking about WROs for the last 5 minutes. What are they really? So WROs indicate to the importing community that there is reasonable evidence that forced labor has been used in the production of shipments likely to pass through a port of entry in the United States, and that those shipments will be stopped for further instructions. Typically, WROs are issued following a detailed investigation by CBP, and that investigation is typically triggered either by human rights and labor-related groups or initiated by CBP itself. And once a WRO has been issued, the importer then has 90 days to prove that the labor used in the production of their good had been treated fairly. And it can do so through documentary evidence such as factory visits, audit reports, supply chain maps, or any other information that they deemed would be relevant in order to support their defense. And if that evidence is not compelling, the importer then must export that product out of the US immediately, or US CBP would seize and destroy the product. And if CBP finds evidence showing forced labor that meets its probable cause standard, then it may issue a finding in the Customs Bulletin or the Federal Register, essentially saying that the goods can be seized and destroyed. Well, the good and similar goods can be seized and destroyed upon entry into the United States, in addition to other maybe other civil penalties. Now, bearing that in mind, what can an importer do to mitigate the risk of non-compliance? So we often advise most of our clients to remain vigilant and to track and monitor ongoing developments that could impact their business. So from a sourcing perspective, which would be of relevance, given that we're talking about WROs, we would typically advise them to evaluate their supply chain, the entire supply chain, and to ensure that no forced labor was used in the production of their good. Now, we might also advise them to consider shifting the manufacturing as well as their sourcing completely outside of the area that the US government deems to be of high sensitivity. Obviously, we've highlighted the Xinjiang region of China, and if China is a big market for you, then that would be a very difficult decision for you to make as an organization. Now that concludes my presentation. I will now pass it on to my colleague, Augusto.
Thank you, Onosong. Thank you for passing me the word and very nice presentation. Well, first, I am Augusto. I am from Buenos Aires. I'm a trade practitioner at Becar Varela. And I would like to give thanks firstly to Ron and Jeff and for my colleagues here at the IPBA for organizing this great webinar. I will try to be very, to not take much of your time. And I will provide a short overview. And the idea, you know, that in Argentina, there has not been many significant updates during the last years. I mean, we are in that, when you talk about trade remedies in Argentina, or mainly in Latin America also, you talk about mainly safeguards, anti-dumping measures, and subsidies, or countervailing duties. I mean, we are aware of the currency rule, the slave labor, and other stuff, but we have no regulation regarding those topics. So the enforcement authority is focusing on the traditional or the classical, or the old tools of trade remedies. But in Argentina, in our history, we catch up later with the development from the Western countries as this type of new approaches to the analysis of international trade and the current and new challenges and the challenges of the future. Well, just to start, as I said, I will provide a short overview of the trade remedies practice in Argentina. In this regard, as I said, the last amendments to the local regulations in Argentina took place in 2008. And during the last years also, there have not been significant changes in the administrative structure of the governmental bodies that conduct investigations. I mean, we have the same technical bodies, so that is something positive, because the technical officers are the same for the last 25 years, so they know the subject, and that is an advantage when you are fighting a defense in the framework of an investigation. There have been some developments regarding China, but in 2017, I mean, due to the termination of the waiting periods of the Chinese accession protocol to the WTO, there were some changes in the status of China as a market economy, as a market economy, and currently, as an exceptional measure to respond to the COVID-19 pandemic, some anti-dumping duties that affected products that were deemed critical for preventing COVID-19 were suspended. I'm talking about syringes, parenteral solutions, some textile products for surgeries. I mean, sanitary products, in order to facilitate the import and the supply of these goods. In the framework of this pandemic, they have released or suspended the anti-dumping duties that were enforced. I will share some presentation. Sorry, I forgot that. Can you see it? Yes, no? It is working, isn't it? Okay, so trade remedies in Argentina, as I said before, when we talk about trade remedies in Argentina, we talked about subsidies, safeguards, but mainly anti-dumping duties. As a party to the 1994 of the GATT 1994, Argentina has regulated the local procedures for conducting investigations and imposing safeguards, countervailing duties, and anti-dumping duties. However, during the last 25 years, Argentina has conducted safeguards investigations only 7 times, being the last one in 2007. All these safeguards were related to textile, footwear, and toys. Subsidies, we have even a lower figure. I mean, only 3 precedents, and all in the year 1996, at the very beginning of this WTO new era. And there were investigations conducted against the European Union with gluten, canned peaches, and olive oil. And as I said, the most likely trade remedy measure adopted by Argentina is the anti-dumping duty. The figure is 450 investigations conducted over the past 25 years. And this figure includes the interim and sunset reviews. Just to have an idea of the governing agencies, in Argentina, there are two main agencies that conduct the technical investigation. These two technical agencies are the Directorate of Unfair Competition, the DCD, and the National Commission of Foreign Trade, the CNCE. The CNCE is in charge of the determination of injury and causality, and among other issues of the investigation. No, but the main focus of them is to determine the existence of injury and causality, and the DCD is in charge of calculating the dumping margin. Both agencies issues a technical recommendation to the Undersecretariat of Policy and Trade Management, who at the same time issue a second recommendation to the Secretariat of Industry that will share the recommendation with the Ministry of Production, who is the guy that decides on the application of the duties. Well, this is some of the functions of these technical bodies. I will not bore you with their functions. The idea is to know that the DCD is in charge of calculating the dumping margin, and the CNCE is in charge of determining the existence of injury or threat of injury and the causality. Maybe to provide some figures, I mean, just to have an idea of the size of the market and the relevance of this issue, I would like to point out that between 1995 and 2020, I mean, during the last 26 years, Argentina adopted more than 230 final or definitive anti-dumping duties. Of those 230 anti-dumping duties, 62% were adopted at the end of initial investigation. I say initial investigations in order to differentiate it from the reviews. I mean, this is the common, the regular procedure investigation, and that's why I say initial investigations, just to differentiate it from the interim and the sunset reviews. And almost 40% were duties that were imposed after sunset or interim reviews. Of these definitive anti-dumping duties, 43% of them were extended at least one. As I said last Tuesday at the first webinar, there is a common practice in Argentina of extending the definitive anti-dumping duties in the framework of sunset reviews. There are some very, illustrative cases, such as the sanitary ware from Brazil, the case of sanitary wares against Brazil, that have been extended for the last 20 years. I mean, almost since the beginning of this practice in Argentina. Of those 230 anti-dumping duties, 105 were minimum FOB prices, 92 were ad valorem duties, and 33 were specific customs values. However, in the last 5 years, the most common anti-dumping duty is in the form of ad valorem duty. I mean, it's an ad valorem duty that is calculated over the FOB value of the imported goods. Almost 80% of the definitive anti-dumping duties were adopted against China, and the other most frequently investigated origins were Brazil, India, South Korea, Taiwan, and certain European Union countries such as Germany or Turkey. And as I said, there were some developments regarding China, but some years ago. You know that before 2017, Argentina has consistently denied the market economy status to China. Therefore, for the dumping margin calculations, the authorities used to consider the normal value of third countries, in general prices of Brazil, if a like product was manufactured there. Accordingly, using this methodology, the anti-dumping margins were huge, and it was very unlikely that a Chinese exporter would participate in an anti-dumping case in Argentina. It was very difficult to get the market economy status, and the export volumes did not worth the efforts of investing in filing a decent defense. I mean, there was so much requirements in order to demonstrate that the Chinese exporter was working in market economic conditions that, and generally the volumes in Argentina, maybe it's an investigation for $10 million export, so maybe it was not of interest of the Chinese exporter to file such a complicated defense. After the waiting periods of the Chinese accession protocol to WTO, I mean, when they were terminated, Argentina did not issue any formal declaration whether it would recognize the market economy status to China. At that time, the Argentine strategy consisted in waiting to see the approach of the US and the European Union to the issue. However, in May 2017, Argentina initiated an anti-dumping case against China regarding the exports of sanitary ware. I mean, I don't want you to confuse. There are two cases that are connected with sanitary ware. It is the same local producer that have filed, has requested the application of an anti-dumping duty against Brazil and afterwards against China. This case was very important because it marked a change in the criteria of the Argentine authorities. Without making any specific declaration, the authorities stated for the first time that for the dumping margin calculation, the Chinese domestic prices were going to be considered for determining the normal value. I mean, when they sent to the importers and exporters the questionnaires, they directly requested the normal values of China in order to determine the normal value and the cost structure, and then the calculation vis-a-vis the export price to Argentina and the normal value in China. Accordingly, I mean, Argentina was in fact tacitly granting market economy status to China without any formal declaration. Some of the most recent cases, as I said in the presentation, the cases of this approach, of the new approach, is the case of safety gloves, cloth irons, refrigerant gases, among many others. Still, I mean, however, there is no case where the Argentine authority has granted individual determination to a Chinese exporter. So it is very tricky, you know, because they didn't make any formal declaration. They just tacitly accepted the domestic prices in China, but they are not giving them sufficient time. I mean, nevertheless of this market status sort of de facto recognition, the Argentine authority requests a lot of formalities to the Chinese exporters. So it is very difficult for them to gather all the information, the documentation, certifications, legalizations, and translations, and public translations by the requested deadline. I mean, even though sometimes the Argentine authority gives 30 days, that can be extended up to 30 days more, but it is difficult for the Chinese to make it. So in practice, I'm not aware, and there is no individual determination for any Chinese exporter currently, up to the date. Even though it
Thank you, Augusto, thank you. Thank you. No, if we can, I want to keep on schedule, but I want to see if you can defer Maybe, no, maybe just defer a few of your points to the Q&A, because we're going to come back around as we go through each of the primary speakers. And so we will have plenty of time, but I just want to try to get the primary presentations in, if that's okay.
Sure. I will.
Great,
I will
okay.
stop sharing the. I will stop sharing the screen.
Okay, and then we can pick up.
Yeah.
We can pick up on that and put it back up. Sure. No, thank you. That's I think that issue of the pressure is very difficult, because to be able to respond to an investigation in that short a time is almost impossible. So it results in almost an automatic failure. And this is a problem in many jurisdictions, I know. And it is one of the persistent problems of the anti-dumping law, definitely. So I want to come back and we can talk about that. But let's shift and Sita, I think if you're ready, I think you have slides as well. You may be on mute still. Yes, I see your microphone is muted. Great. No, we're still not hearing.
Am I audible now?
Yes,
Okay,
very good.
fine.
Yes,
Great.
thank you.
No problems. Okay, good morning, good afternoon, or good evening to people who are joining us from around the world. And I would like to make a few generic, comments and a few highlights of the changes that have happened in India during the past 1 year or so. As you all know, India has a very, large number of cases on anti-dumping, and also maybe slightly large number of cases on safeguards, but the subsidy cases are quite less, though maybe 9 or 10 cases, 12 cases, something like that till now. But anti-dumping is the mainstay. And then, I would like to share a presentation with you all to take us through. Okay. Now, there are certain legislative changes that have come up, and this is not yet come into force. This is a draft anti-absorption provisions. This anti-absorption provisions defines absorption as a situation where there is a decrease in export price without any commensurate decrease in cost of production, export price to other countries, or resale price in India. However, this provision does not require, like what is required in European Union, the insufficient movement in the resale prices or subsequent selling prices of the imported product within India. This is some difference in terms of the concept of absorption. And India also, in an anti-absorption provision, would look at redetermining the normal value for calculating a revised dumping margin and redetermine a non-injurious price for calculating the injury margin. And based on the new dumping margin and new injury margin, the new duty rates will be determined. The way I look at the provision, the draft provision, is that this is looking at a decrease in export price as a triggering event for conducting a limited midterm review to reassess dumping margin and injury margin without undertaking a complete injury examination. That's how the provisions have been design as of now. We don't know what will be the final shape. And in terms of other changes, the central government gets a power to suspend the existing duties for a period not exceeding 1 year. And the time period for completing a sunset review has been reduced by 3 months. That's basically, it was 12 months earlier. Now they say 3 months prior to the expiry of the duty, one has to complete the investigation. Otherwise, earlier it used to be the situation where on the last day, the final findings will be issued, but the finance ministry will take additional time to come out with the customs notification imposing the duty. And therefore there are some issues. So now they have amended the rules to state that the investigation shall be completed at least 3 months prior to the expiry of the existing duties. And again, there is one more amendment. It says the levy period can be less than 5 years in a review. It can be 2, 3, 4, or 5, whatever the time they want, not exceeding 5 years. The earlier, it was taken for granted that it will always be for 5 years. Then there are certain changes on the exporters questionnaire, importers and user industry questionnaire formats and the petition formats. The major change in this is that most of the data, especially those relating to the profit and loss account of the exporter relating to the period of investigation for the company as a whole, as well as the profit and loss account for the product as a whole. These two items, they needed to be certified by a CPA or a practicing chartered accountant. But now that certification requirement has been removed, so that eases the life of an exporter who is participating in an investigation. Okay, now there is a tussle between the authority that conducts the investigation, that is the Director General Trade Remedies, which is a part of the Ministry of Commerce, and the implementing authority, which is the Ministry of Finance, which has to impose the duties. Now, if you see this table down below, so far, whether my screens are visible?
No, I was going to ask if you want to share your screen.
Okay.
I think you will need to share. Yes.
I'll share the screen.
Okay. And we're at about the 6 minute point. So.
Okay, fine.
Okay.
Not an issue. I'll be able to complete it. Okay. Let me just. Yeah. Now I think. Okay. If you see the screen. And I don't know whether this is coming out because from my screen.
Yes, it looks good.
Okay. And the number of findings are 37. Out of the 37, there are positive findings in 33 cases. And the duties imposed were only in 15 cases. And the Ministry of Finance rejected 18 cases of findings. That the rejection rate is really high. And in the next year, that is 2021 till now, the rejection is much higher at 63%. So this is one major problem that we are facing. Positive recommendations by the investigating authority no longer results in a levy, and a lot of uncertainty prevails even after positive recommendation from the DGTR. Nobody knows what is the reason why the Ministry of Finance has started rejecting the recommendations. So all that we are guessing is imports of intermediary products necessary for Indian MSME, that's micro, small and medium enterprises, to survive. This would cause injury to them. So therefore, no duty should be imposed. Someone says may lead to monopoly or duopoly in India in some cases. So the duties are not imposed. and someone says it is not in public interest, so they are rejected. But no one is sure of what is the reason. But this is undoubtedly creates uncertainty. And there is yet another problem that's coming up now. It was there earlier, but it was not very serious. When in a case, an exporter does not get a dumping margin, he gets a negative dumping margin or a de minimis dumping margin, you do not impose a duty. That India also does. But in the case of a sunset review, normally the sunset review is to cover existing measures. So if against an exporter there are no measures, that exporter will not be covered in a sunset review. But India says that a sunset review covers the whole of the subject country, which includes all exporters, including the ones who are not subject to the existing measures. And this is a new trend which has been created. And against this trend was actually challenged. There were a lot of criticisms, and authority initiated a fresh investigation against an exporter, which was granted a nil rate of duty. But then after initiating it, very recently, they terminated it, saying that it is to be covered in a review and no fresh investigation is required. Now these cases are pending in the Supreme Court and some of them in the High Court, but there is no last word on it in India. Let us wait and see what is it. And then in the sunset review, there are some more problems. The duties are normally increased or decreased in India, unlike European Union or US, where it is only either termination or continuation. But because there are changes in the rate of duty, all permutation combinations, whether somebody gets higher, somebody gets lower, previous duty continued for all, somebody gets a previous duty, somebody gets a new duty, duty is reduced for all, or a new rate for a new entity, old rate for an existing entity, all kind of permutation combinations you can see in the findings. This is again another area where there is no clarity, no certainty. And the post-POA data, also one more issue which people used to provide as a part of the questionnaire in the past, but now there is no uniformity in collecting 6 months post-POA data. In some cases, the authority has stated in the sunset review initiation notice, they may consider a post-POA data, but they have not considered it. And some cases, they have not even bothered to consider it. There is no hard and fast rule, but if they follow the standard practice, standard global practice of not going beyond the period of investigation, maybe that will give certainty to everyone. And with this, I think my short intervention, I would like to conclude, and I'm open for any discussion or any questions on the Indian practices. Thank you, Jeff, and thank you all for this opportunity to me.
I don't know. Thank you very much. Very interesting, and we have a lot to talk about. I think it's time for Professor Bala. Raj? If you can stop sharing your screen,
I've done that.
Sitha, there we go. Thank you very much.
Well, thank you very much, Jeff and Rhonda. It's Jeff and Rhonda who really do all the work, not only behind the scenes, but of course, as you see them, and we're all grateful to their hard work in making this possible. So thank you. I would like to talk about one of the major developments that have occurred in U.S. trade remedies that was really not given a lot of attention amidst so many other stories, climate change, COVID, Afghanistan. But this story is worthy of our attention, and it's about currency manipulation and its links to illegal subsidization. I personally have been fascinated by foreign exchange markets ever since working on them as a Federal Reserve lawyer at the New York Fed, and then as a visiting scholar at the University of Hong Kong back in 2007. And as you know, there really are no rules in the GATT WTO system, that is the multilateral level, that deal with currency manipulation. There are a few provisions in GATT Article 15 on frustration of purpose. There's some reference to looking at the IMF and its articles and maybe trying to consult through the IMF. As you also may know, that some free trade agreements, US-Chile, USMCA, have started having a few modest provisions about currency manipulation. But what we got over the last few months, really actually, maybe to be a little bit more precise, starting back in May 2019, was something hard and fast, and that was unilateral. The United States took action against currency manipulation and its links to illegal subsidization. And the respondent was Vietnam. In particular, the subject merchandise were passenger vehicle and light truck tires, PVLT tires, of Vietnamese origin. And they were said to be subsidized, but the nature of the subsidy was the State Bank of Vietnam, Vietnam's central bank, their Federal Reserve, artificially depressing the exchange rate of the dong against the dollar, the dong, of course, being the Vietnamese currency. And after years of frustration on the American side of trying to get WTO rules against currency manipulation and its links to subsidization, the USTR, the Treasury Department, the Commerce Department, and the International Trade Commission all took collaborative action. Now, this is a bipartisan story. This is not a story that the Trump administration took action and the Biden administration backed away from it. Far from it. Although the style is different, there's a clear unity of substantive purpose. So we start, as I say, in May 2019 in the legal trenches. Donald Trump's Commerce Department suggests two changes to the regulations, the Commerce Department regulations that deal with CVD, countervailing duty investigations. The first one is, as we all know, the specificity test in CVD cases. We know from the WTO agreement on subsidies and countervailing measures that an alleged subsidy is not illegal unless it's specific to an enterprise or an industry. And that's a rational test, because we've got to differentiate a subsidy that's generally available, like free COVID vaccines or free electricity to a textile factory, free COVID vaccines from specific subsidies like free electricity to a textile factory. We want the COVID vaccines for everybody, but we've got to look at the textile factory as being a specific beneficiary. If a complainant, like the US, were to allege an offending government, say Vietnam, that their subsidy is red light, that's strictly prohibited, meaning it's an export subsidy or an import substitution subsidy, then the complainant, the US, can invoke an irrebuttable presumption that the subsidy is specific. That's great. We lawyers, depending on what side of the case we're on, we like an irrebuttable presumption. That's going to help the petitioner, the US, win. The problem was, and is, under the SCM agreement of the WTO, currency manipulation is not clearly identified as an export subsidy. It's not indisputably red light. So claimants like the US would have to argue a yellow light case, an actionable subsidy. So they had to produce evidence of specificity. That's harder for the petitioners. So tired of waiting for the WTO to formulate express links about subsidies and currency manipulation, the DOC, the Commerce Department, simply said, under the specificity test, a group of exporters is a group of enterprise and they are specific. In other words, the activity of exportation, rather than the merchandise like textiles, the identifiable product, is enough to pass the specificity test, because that specific group, exporters, benefits from currency manipulation. Artificially holding down the exchange rate of the dong against the dollar is going to make Vietnamese exports cheaper in US dollar terms to American buyers, and it's going to make American exports more expensive in dong terms to Indian buyers. Now, the second change Donald Trump's Commerce Department made was the benefit test. The Commerce Department just said flatly, competitive devaluation by a foreign country constitutes a countervailable subsidy that confers a benefit to producer exporters, our Vietnamese PVLT tire producers, and to their importers in the United States. So there it was. And this May 2019 rule gets finalized in February 2020 with effect from April 2020. Bottom line is the previous administration unilaterally eases standards for American producers to hit foreign exporters with anti-subsidy suits by removing any worry about the specificity test or any worry about who's benefiting. So then the next step in our saga, as it were, is in January 2020, Donald Trump's Treasury Department issues a report on currency manipulation and identifies as a villain Vietnam. And remember that under US law, there are there's a three-pronged test for whether a country is going to be branded a currency manipulator. First, that country, in this case Vietnam, has to have a significant bilateral trade surplus with the United States. That means $20 billion trade surplus over 12 months. Second, the foreign country has to have a material current account surplus overall with the world, and that means 2% of its GDP over 12 months. If you take the current account surplus in the numerator and GDP in the denominator, that country has a current account surplus of at least 2% of its GDP. And then finally, the third criteria to be a currency manipulator, third criterion, is that the country engages in persistent, one-sided intervention. And what that means is repeated purchases of foreign currency, buying the US dollar, selling the dong in at least 6 out of 12 months. And the purchases of the US dollar constitute 2% of its GDP. Well, Vietnam actually met the first criteria, bilateral trade surplus, very close on the second, overall currency surplus, current account surplus, and very close on the third in terms of engaging in persistent one-sided intervention. So America didn't actually brand Vietnam as a currency manipulator, but put it on its watch list. And the US Trade Representative, following the Treasury Department, said the State Bank of Vietnam has been unfairly devaluing the dong against the dollar by 7 to 8.4%. And so basically Vietnam was judged guilty of currency manipulation without officially being branded a currency manipulator. Now, Mr. Biden, he picks up the Trumpian narrative and in August 2020 launches a CVD case, his Commerce Department does, or actually picks up a CVD case that had been launched, I should say, during the Trump administration. And so in May 2021, the Biden Commerce Department, for the first time ever in US trade history, rules that subject merchandise has been unfairly subsidized due to currency undervaluation. And the CVD rate, 6.23% to 7.89%. Not huge, but not de minimis either. The ITC then follows the Commerce Department in June 2021, says, yep, there is material injury to the U.S. Domestic producers of passenger vehicle and light tires. So there you have it. The combination of two administrations, 4 U.S. agencies acting collaboratively and unilaterally have gone ahead and implemented what we can now call the currency rule. Now, not all is well that ends well. Even though the USTR and the State Bank of Vietnam negotiated a solution to end the Section 301 investigation, very cleverly, and for those of you who like foreign exchange markets, you'll think this is actually really cool. The State Bank of Vietnam is apparently, and this is apparent, I don't want to accuse them, is actually manipulating its currency through the forward foreign exchange markets. I mean, hey, you can use forwards to depress the value of the currency against the dong against the dollar by simply selling 6 months right out and pegging and pushing a rate. Now, the U.S. is continuing to collect data on everybody. You could be a friend like India or Switzerland. You could be a foe like China or Russia, or you could be a frenemy like Pakistan and Saudi Arabia. Doesn't matter. American authorities are going after exchange rate manipulators and their links and the links of exchange rate manipulation to subsidies. So in one sense, this is a piece of the Sino-American trade war. And you heard it here first. I'm going to call that the forever trade war. We'll probably do an IPBA panel on that forever trade war. But it's really against all foreign governments that dare to manipulate their currency to boost their exports. So with that, let me stop and thank you for your attention.
Thank you very much, Roz. Just amazing all the way through. In 10 minutes. Thank you. And so we turn to Nikolai in Luxembourg.
Yeah, thanks very much, Jeff, and thank you, Raj. I think this was truly fascinating, also for me to hear, because Augusto asked me 2 days ago in the other seminar whether the EU is contemplating something similar, and I have to say honestly, I do not know. I mean, unless it's being talked about in the corridors. So far, we have not. But it seems like we are always one step behind the US on all these matters. So let's see. The human ingenuity is limitless in that sense, at least on the insofar as we can copy it. Yes, my name is Nikolai Kukuatsky. I work at the European Court of Justice. I used to work in the European Commission's legal service, and I dealt with dumping matters there. So this is an issue close to my heart, and I enjoy this subject matter thoroughly, trade defense remedies, even though many people will find it rather boring. So today I will talk about two issues. For one, the application of this new methodology called the significant distortions methodology. And then for another, the more recent practice of the European Commission to countervail transnational subsidies. So in other words, I look at one example from the world of anti-dumping and one example from the world of countervailing duties or anti-subsidy duties. But first, anti-dumping. I'll start with the former. We've heard sort of the general idea of anti-dumping duties is to I would almost say countervail, sort of to tackle unfair trade remedies, unfair trading practices. To those who find this a bit of an abstract idea, I think it's always nice to recall this one example that Jacob Weiner gave. So just after the American independence, the English manufacturers dumped products so cheaply on the US market so as to crush, and use the word crush. And I think it's a nice word to use because it shows the sort of this willfulness, right? This intention to destroy the young American industries. How dare they separate from the great British Empire? And so the idea behind anti-dumping as such is an idea that derives essentially from competition law. At least on the European side, we want to make sure that there's even competition here, right? We want to rebalance the scales. And so it's traditionally been viewed as sort of this private practice phenomenon. There's someone who's evil and he wants to undercut you and wants to, undercut being sort of the term of art here. He wants to sell it at a lower price than you and thereby drive you out from the market and take your market share. Now, as I said, traditionally, this is a private enterprise phenomenon. Now, we have this new significant distortions methodology in the EU, which, like the non-market economy methodology, somewhat turns this idea on its head, because essentially between the lines, it says, well, in certain circumstances, it's not your prices, you exporting producer or you producer in general, not your prices that are at fault here. It is the system that under which you operate, right? It's the input sort of product and elements that distort your price, the ultimate price, even though you do everything correctly, everything by the books. And so the idea is here that, okay, there are these distortions that originate up the value chain and they trickle down and they have an impact on your costs. And therefore the ultimate price, we cannot trust any of the costs you report. And so the ultimate price is distorted. And this goes from electricity to labor to sort of the general regulatory environment. The Commission has taken a very broad brush on this issue. And because of these distortions, you then have this comparative advantage, and that's why we have to, I'm going to say, punish you with duties. And that in short is the rationale of this new methodology. We can't trust any of the costs here, and therefore we have to do something about it. Now, it's country neutral on paper, but so far it's only been used against China. And at the same time, the non-market economy methodology has been removed for all WTO members. So you see sort of one thing replacing another between the lines. Let's look at an investigation briefly. Steel road wheels. These are basically these wheels you put on light commercial vehicles or even just passenger vehicles. And this was the first investigation, if I remember correctly, that applied this new methodology. And there, of course, you will not be surprised that duties were imposed. But what is rather interesting is how the Commission found these distortions to exist in order to result in duties. And the Commission sort of uses this two-step approach, and as a first step, or so let's say sort of the belt and brace approach, right? So you have the first layer of finding distortions, which is horizontal. It has this report. It's called the China report, through which it states these horizontal distortions across the Chinese economy. It has researched this, and it says, well, there's this language that it copy pastes in all of these investigations for the first layer that is the same. And it basically says, okay, the Chinese state is intertwined with the Chinese Communist Party. As such, it engages in this interventionist industrial or economic policy that seeks to serve the Communist Party's ideals. So this is not the decision of sort of the market forces that lies behind this. And these sort of interventions run from industrial planning to control and direction of the financial markets. So a discriminatory application of bankruptcy rules, for example, all the way to the general level of the regulatory environment. And so, as I said before, it's this transversal idea that everything is distorted in the Chinese economy. You can't trust anything because of this general regulatory environment through which then everything sort of follows. And so you have legal distortions, institutional distortions, and general regulatory distortions. So a beautiful mosaic as such. And then the second layer, the brace approach then is, in that sense, is sort of this vertical distortion that are then established for the individual industries. So you have the steel industry in this case and the automotive industry. And so the Commission, again, through the China report, in which it sort of specifies the various industries. If you can hear my son yell in the background, you will see he's having a lot of fun. So the Commission uses the China report also for these specific industries. So it says steel, for example, which is this bread and butter product of any dumping lawyer, is distorted for the following reasons, and it lays down the 5-year report and all these individual localized directions from the provinces on how steel, the overcapacity affects the prices and so on. The same for the automotive industry. So as you can see, as I said, 2 layers, horizontal and vertical layer. And with that, it comes to the conclusion, well, everything is distorted, sorry, we can't trust any of your inputs. And so what it does is it goes ahead and it replaces all these inputs individually. It disregards not only cost of production, but also your SG&A, your profit, because it's all follows one after another. It's quite a tedious exercise because it has to go to a representative country that it deems to be of similar economic development as China. Very often it's Brazil. Turkey has been in the game. South Africa has been considered, and so it's on the one hand a representative country that is where no distortions, of course, exist. But at the same time, it's also a more practical approach because they want to find. They need the data, and you need to have a country that provides the data freely. And if the Brazilian Ministry of let's say Ministry of the Economy puts down the average electricity price in this province, then you can take it quite easily, right? So there's a policy approach to this, but there's also a very practical aspect. So yeah, as I said, this replacing of all the individual input products makes an already quite complicated field even more complicated. And so I think the impact that this has on producers and exporters is that it's become very, very difficult for you to show that you are not operating according to these distortions. Because if you have this general layer that applies to everyone, how are you going to disprove as a small, let's say, family enterprise that you're not subject to discriminatory application of the bankruptcy laws, right? If you've never been bankrupt, for example. And so the issue now, you're moving away from this 4-factor approach that under EU law you had to show 4 factors under the non-market economy methodology to show that you operate within this bubble of market economy forces. You're moving away from this difficult approach, but manageable approach, not like in Argentina where it's impossible to meet, to an approach that is really in practice impossible to meet. And so I think the system has sort of changed the way then we look at the response to an anti-dumping investigation. So from what I hear, there's a lot of focus now on the dumping side, on the calculation side. The real specialist here wins sort of the game at the end, because it's those people that know how to manipulate an Excel sheet, that know how to request which adjustments in which particular cases that can lower the duty rate, because for everyone else it is sort of there's distortions and we'll just set the value as such. The second point is that, as I said, it's very difficult for you to prove that these distortions do not exist for you. So what I think should be done more is to be engaged in the Chamber of Commerce. I mean, we have these chambers of commerce in China. Membership is mandatory in these industries, but these chambers of commerce have traditionally been very reluctant to be active in EU investigations. I mean, then they're very closely connected to the Chinese state, so I understand where the idea comes from. The Chinese state has never intervened in anti-dumping investigation. Anti-subsidy investigations are a different thing in that sense. So what I would think would help here is further engagement of the chambers of commerce, and why not a court case? I mean, everyone likes a good court case. I love court cases, and these chambers of commerce have recently been actually deemed to be admissible litigants before the European courts. That was long the question, because guilty as charged. I was one of the agents who had argued they don't operate like European chambers of commerce. You know, they're essentially an extension of the Chinese state, and so there should be different requirements. But the court said, no, don't worry, this is a stupid argument, we'll not go with it. So as I said, I think further engagement by the chambers of commerce would be something refreshing, and in any case, a sort of general challenge to the methodology would also be welcome. So far, the only promising challenge is that this methodology violates the Chinese accession protocol to the WTO, and that case remains pending. So I don't want to say anything on this, but just so you're aware, there's one case that is very interesting that's pending on this particular point. Now, anti-subsidy investigations, the anti-subsidy instrument, and transnational subsidies, and this is quite a significant development, and I'm sure 2 minutes left. Sorry about that. So I'll be very quick. Yes, time is running against me. First, idea is basically you have subsidies given by government A to an operator operating in the territory of government B for that operator to export the product to a third country. Now, the EU has said we have to countervail, in that second territory, the duty, the financial financial encouragement, the financial incentives given. And to be very short, in glass fiber fabrics case, what was done was the following. Egypt has a special economic zone, special free trade zone. Chinese-owned companies, but they're Egyptian companies, operated there, manufactured a product, and sold it to the EU. They had received financial incentives from the Chinese state. So you see the problem here. You have Egyptian companies that are being supported by China. So the traditional idea of territoriality under the SCM, under the Agreement on Subsidies and Countervailing Measures, the idea of territoriality, I can only countervail according to the authority that is also in charge giving money, suddenly disappeared, because what the EU has now done is countervailing money coming from China in Egypt. And very briefly, the way it's done this, it's applied for the first time in EU law, the articles on state responsibility. And with that way, it was able to bridge that gap between practice and reality. And now the big question in the room is this WTO conform? Again, we have a challenge before the European courts. But the only point I want to make is, does this impact you if you are a producer in that in one of those special economic zones? I think right now it does not. However, this is clearly a sort of engagement with China's going global policy, right, with the Belt and Road initiative. In this particular case, the only reason why the Commission was able to countervail this is because there was an international agreement between Egypt and China that said, I, Egypt, accept and I welcome your money for companies operating in my zone. So you could make these financial incentives your own. If this agreement had not existed, the Commission would have had massive problems. And so what you need is very clear attribution language in some sort of agreement, or I don't know how it would be done in practice. Otherwise, you cannot tackle these subsidies right now, at least. And of course, you have to have a countervailable subsidy. I mean, there are multiple boxes, but the most important thing is this agreement. Sorry, I've run over time, but thank you very much also for this.
Not at all. No, that's very interesting, and I think in the discussion of where this might go, we had a little bit of discussion during the last panel about the creativity of governments in dealing with trade distortions and these kinds of issues. And Raj, you know, the currency issue that you mentioned, and Nikolai, this is you know, infinite creativity in terms of are the old instruments capable of dealing with the modern problems, and if not, then we need to create new instruments. And I want to come back to that point, but I want to, at least for the moment, open it up to our audience and see if anyone, you know, if anyone has any questions or other topics that they'd like to add to it. Please, you know, please unmute yourself and join us in the conversation. Hearing none, for the moment, I will take the prerogative, and I would love to ask Gosong a question to start our discussion. I'm fascinated by the forced labor human rights issue, and it is becoming one that is much more important for many companies to understand. And I'm very interested in after hearing some of the other discussions, if there's any kind of a price or price comparison element in the forced labor calculation. Is customs looking at prices, or is it simply the source of the product that's coming in? Are they looking at underpayment of wages? Are they looking at subsidies? Are there elements that are similar to sort of a price comparison that you would make in an anti-dumping or in a subsidy kind of analysis?
Okay, can you hear me now?
Yes.
Thank you very much again for that question. And we've had a number of conversations with the folks at CBP, and unfortunately, that particular issue has not come up in our conversation. But I would presume, bearing that in mind, I would presume that if there is any indication showing that forced labor was used in the production of that particular good, then that would be an area of concern to CBP. And from an importing perspective, you would basically have to show that there was no forced labor involved in the production of your particular product. Now, bearing that in mind again, with the geopolitical implications between that's on the way between the United States and China, it does seems to me that if the law which is currently going through Congress does pass, that at that particular time, in that particular instance, dealing with products originating from the Xinjiang region of China, that might be a factor. I don't know if that answers your question.
Yes, no, I'm just curious, not curious, but in seeing this, as I say, this creativity that governments are using to expand, especially trade restrictions and new measures, new ways to deal with new issues that are coming up, and just how that calculation would work. But I see that Raj is interested and raised his hand, and please.
That's a great question about, if I've got it right, whether to what extent do prices come in on a forced labor determination with a view to imposing a withhold release order, WRO. And I agree with everything that Ngosang said. I just would add that the CBP uses the International Labor Organization 11 criteria for forced labor. They're set out in a very nice pamphlet that the ILO published, and they're based on a 1930 forced labor convention from the ILO, and that none of them directly addresses pricing. It's abuse of vulnerability, deception, restriction of movement, isolation, physical and sexual violence, intimidation and threats, holding back identity documents, withholding of wages, debt bondage, abusive working and living conditions, and excessive overtime. And I guess the closest would be number 8, withholding of wages, maybe 9 on debt bondage, and then maybe either abusive working conditions or excessive overtime, 10 and 11. But it's not built into, none of those criteria are built into the pricing of the merchandise. So at least so far, CBP is trying to follow the multilateral views on what constitutes forced labor. Interesting.
Yes, I see it as another tool, I guess, is another way of trying to deal with this. And I know that in addition to customs, we are starting to see other agencies act based on human rights as well. So the Treasury Department, its Office of Foreign Assets Control, is designating parties in China who it believes are involved in, has reason to believe that are involved in forced labor, which creates financial restrictions. And in addition, the Export Administration, BIS, is also naming companies. It's an export ban, but it is a very different way of trying to address the concern and to bring human rights much more into trade, which is in many ways a contrast to a traditional anti-dumping case, which really doesn't. It focuses on injury to a U.S. industry, and in many ways, I think the industry condition maybe there are lost sales and maybe unemployment or lower employment. And so it does have some relationship to workers, but in a very different way, sort of indirectly through the industry, as opposed to a direct concern about workers that are outside the US. So it is a tremendous expansion, as you've identified, Ngosang, for this to be now another tool in the toolbox. So I would love to hear more, Sitha, about some of the issues that you're facing in India and that companies are facing. It sounds as if there are some disappointments, I guess, in terms of how the government is reacting, and there's not a lot of information. In the context, I'm wondering if what's happening is that either the courts in India or in fact, we can talk about the WTO. We haven't talked about the WTO that much, but in the absence of a really functional WTO dispute system, is that giving governments more flexibility, more freedom, because they feel that they will not be held accountable for their implementation of the national dumping laws?
I think the way in which India is implementing them, Indian government has a record to state, like the old gramophone records repeating the statements. They keep telling us that not one anti-dumping case of India has been taken to WTO by any of the member countries, except once by EU, but that was also at the consultation stage, and one by Bangladesh on again at consultation stage. That was it. So they are saying that no, what we are doing is well within the WTO norms, and whatever we are doing, maybe you can call it as innovative, but that's well within it. More than that, what I would think is in India, there are two sets of forces which are equally good and strong. One from the importers and users of the product, and the other, the domestic producers who are seeking the duty. So there is a tug of war between these two, and the current situation is that the importers and users lobbying is more powerful, it appears, and more duties are not imposed, more cases are getting rejected. But I think this is a time and a phase which will change immediately if there is some change in the players involved. Probably, the Commerce Ministry personnel or the Finance Ministry personnel, or at the political level, if there is some, re-looking at the issue. But I don't think it requires any, WTO intervention at this stage. And maybe it's good for exporters if duties are not imposed. And in any case, the affected domestic industry has no other option but to suffer. So they are only going to the Indian courts. I don't know what is going to happen.
It is, depending, free trade versus protection. I mean, there are always, always those questions. And so maybe it is in that mode that we're seeing more of a balance toward free trade. I hope there are, and this would be a subject for many discussions, domestic systems like adjustment assistance or, support for industries that are suffering but do not get relief. That's a whole nother topic, I know. And we're getting close. I have to mention that we're getting close to our time. So I think we do have time for a few more comments, maybe one more question. If any of you have questions for each other, or if comments on the discussion so far, please speak up.
I have one small question to Noksong Phonekam on the forced labor issue. I thought, the existing system was to come out with a list of products where the US Department of Labor has a reason to believe that they might have been produced using forced labor. And that list of products from countries, the named products in that list, are not allowed to be supplied to federal contractors or a federal government or something like that. But what he has been talking about now is a new law which is going to come up, and that is specifically for specific countries and regions. What's the variation in this new one as compared to the existing one? Hello?
Thank you very much again, Sita, for your question. Yes, traditionally, the forced labor law was based on the 1930 Tariff Act again. But to your point, the new law, which is working its way through Congress, is specifically tailored to target shipments from China, from the Xinjiang region of China. So I think that would be the difference, unlike the authority that's found in the 1930 Tariff Act, which basically allows the U.S. Customs and Border Protection to be able to ban products from entering the U.S. if they find that forced labor was used in the production of that particular good. So that would be the difference, is that the one which is working its way through Congress is specifically targeted at shipments coming out of a region from China.
Okay.
I would presume is due to the Sino-US trade war. I think that's sort of part of the larger context, in my opinion.
Okay, thank you.
And maybe Professor Raj, you can add to that too, if you've got some.
I think I'm hearing, Raj, we do need to wrap up, but I'm hearing a number of tremendous program ideas. The growth of human rights in trade, or the relationship between trade and human rights, is something which finally I think is starting to come into more prominence, and it's been many, many years, and it's been a difficult battle, I know, for many, many lawyers, but it seems to be much more common. I heard that yesterday that the European Union is considering adopting a forced labor ban, very much like the U.S., and that's something that is in the works, that they've been finally, some of the proponents of that are successful. I also love your idea about the endless trade war, which I think is something that we have to look at more, and we have to spend more time on, because how companies and how businesses will survive in an endless trade war is something which we've all been living recently. But if that's going to be endless, then we need to get better at it, so we can keep working on it. But I'd like to thank all of you and thank our audience. I think we could talk about these topics for hours, and we'll have to find a way to do that at some point. But for today, I think we're finished, and I really appreciate all of the time that each of you have spent on your presentations, and the time dedicated today to helping the IPBA understand and learn about these very important issues for business. So I'd like to thank you all, and I think Rhonda would want me to say, I think the program is being recorded and will be available in the future. And please keep your eyes out for future IPBA programs. There will be more coming along, and they may not be better than this, but they'll be very good. So please join us, and thank you all. Join me in expressing appreciation for our panelists. Thank you again. And Rhonda, I'll stop there if there's any final points.
That's all. I just wanted to say thank you to everyone for joining, and thank you to the panelists.
Thank you.
Okay.
Thank you.
Thank
Thank you
you.
again.
Thank
Good
you.
night, good afternoon, good day.